I now recognize the chairman of the Subcommittee on the Constitution, Civil Rights and Civil Liberties, the gentleman from Tennessee, Mr. Cohen, for his opening statement.
Thank you, Mr. Chair. I strongly support H.J.Res 79, which will remove the arbitrary ratification deadline for the Equal Rights Amendment imposed in 72 and ensure equal treatment under the law regardless of sex. I'm an original co-sponsor of the measure along with 216 other members of Congress. Unlike my friends on the other side, I don't get stymied on process. I stand on principle. And you try to do things to make the American Constitution better and the American public better and the lives of Americans better, and you try to work through process. You don't use process as an excuse for not taking women forward, for not reforming our Constitution, and for not making progress. The same type of activities they're using over in Longworth to oppose impeachment. Process, not the truth that the president has abused his power, subverted the Constitution, and tried to help a foreign power, Russia, work its way against Ukraine unless Ukraine helped him with his political fights against Biden. So process is not the answer, it's an excuse, and it's been an excuse for centuries with the party on my left. The ERA was in fact approved in both the House and Senate by overwhelming bipartisan majorities in 1971 and 72 respectively. Republicans even voted for it then, the grand old party. The Constitution instructs that after a proposed amendment receives the required 2/3 of the vote in both the houses, it has to be ratified in 3/4 of the states. In the decade after the ERA was sent to the states in 72, it was ratified by 35 of the 38. But for decades, that progress towards equality stalled. A well-organized counter-movement scared the American people into thinking that a guarantee of equality would somehow harm women who stay at home to raise their children and would erode American families. That same well-organized counter-movement destroyed the grand old party and made it the party that it is today. What has started as a matter of broad consensus became yet another divisive issue in the culture wars. Today we know better. We know that in the year 2019 it is unacceptable that women still are not paid equal wages for equal work. We know that no Republican voted for that bill that we had to have equal pay. We know that when women are treated with equal dignity and respect in the workplace, in the home, and by our institutions of government and our society at large, all the people stand to benefit. And we know that a simple but fundamental guarantee of equality should be welcomed rather than feared. At the same time, it is now more important than ever to affirm that women have an equal place under the law and especially under our nation's Constitution. There's a play on Broadway about how important it is for women and for young girls to see that their Constitution respects them. That is the way we should be here in Congress too and try to achieve it. Although women have achieved some measure of equal status under the 14th Amendment, that progress is fragile. As the Supreme Court has moved to the right, it could backtrack from foundational decisions, as it has in other areas, and jeopardize the many advances that women have made. Meanwhile, there are dark currents in our politics and culture seeking to undermine women's status in our society, whether it is by threatening their health care, which I should submit, no Republican voted for the Affordable Care Act, even though they say they're for your health care, they don't vote for it. They say they're for eliminating the prohibition on pre-existing conditions, but they don't vote for it. So they objectify women in the workplace, and they ignore and even condone gender-based violence. In the face of these challenges, I was heartened by the witnesses and the extraordinary tenets at our hearing on the ERA of the Subcommittee on Constitution, Civil Rights, and Civil Liberties back in April. We learned from that hearing the U.S. Constitution was the only major written constitution in the world that lacked the provision declaring equality of the sexes, which Professor Kathleen Sullivan properly described as, quote, a national embarrassment to the world's leading democracy, unquote. We also learned Article 5 of the Constitution largely commits Congress the authority to determine when an amendment has been validly ratified once the requisite 3/4 of state legislatures have ratified it, including the authority self-imposed time limits to ignore any rescission of ratifications. Yes, the Constitution gives Congress that right, just like it gives Congress the right to determine what is impeachable. A few years ago, Justice Ruth Bader Ginsburg was asked in an interview what amendment she would most like to add to the United States Constitution. She answered it would be the Equal Rights Amendment. As she explained, the ERA means that women are people equal in stature before the law, and that principle is in every constitution written since the Second World War. Justice Ginsburg said she would like her granddaughters, when they pick up the Constitution, to see that this is a basic principle of our society, the same as Heidi Schreck said. I look forward to that day. The ERA was first proposed almost 100 years ago, and Congress passed it overwhelmingly almost 50 years ago. Now, with the 38th state poised to potentially ratify the ERA, process must not stop us. when we know the process is really on our side. Congress must once again do its part and repeal the arbitrary ratification deadline and help honor Justice Ginsburg's wishes, and I'm sure those of Abigail Adams too, if she were around to speak, and wish the Constitution explicitly state the basic moral principle that men and women are equal before the law. I strongly urge the committee to report H.J.Res 79 favorably to the full House and bring the Constitution and women into the 21st century. I yield back the balance of my time.